training session. And
We have, Commissioner Savory, we have a few items before we go right into the training session.
Okay.
We don't have any citizens here for input, it looks like, but there's call to order, typical process there, and then citizen input. We have minutes for the Planning Commission for the May 10th, 2021 to adopt.
okay, I didn't even.
I'm sorry, that was for, I'm sorry, I've got the wrong, we have, let me get to the right place here. We have the consent item, we have the final findings, rather, for memory care, final findings to adopt for memory care, which were in your packets.
Okay.
And so, and then we have citizen input, which I don't think we'll have any, and then we'll get into the work session.
So we're going to have the final thing on APP 21-01
Yes.
and DR 20-03 and CUP 20-02 memory care. Final order. Okay.
So we'll need a motion for that.
Yeah, we do have a quorum, so. Okay, I'll entertain a motion to approve APP 21-01, DR 20-03, and CUP 20-02 memory care.
So moved.
Do I have a second?
Second.
All in favor, say aye.
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 Opposed? Okay. Okay. Do we have, and then we have to approve the minutes from the last meeting?
Actually, no, there's no minutes for you guys to, we can go right into the work session since there's no citizens here
Okay, let's do
for
that.
comments. So leading into that, just wanted to start out with some background before I turn it over to Joe Lindsay. At our May 24th Planning Commission work session, we did a brief overview of Planning Commission findings of approval and denial, and the code basis for decisions, and dialogue with the commissioners around approval criteria. We asked what would be helpful for staff reports in that same work session and presentations, and better defining the code and the basis for staff recommendations. And we also asked if it would be helpful to have work sessions and trainings for additional information, and we received positive feedback on that. That leads us into the work session tonight. Joe Lindsay, our attorney, is here tonight with us. He's going to provide a presentation tonight, and there'll be Q&A time here as well. The focus is on the quasi-judicial permitting and hearings process. There'll be an opportunity for questions, as I mentioned. I just wanted to mention that we really appreciate Joe being here tonight. He's provided staff with excellent guidance, and with that, I'll turn it over to Joe.
Thank you.
Thank you. Good evening, commissioners. Excuse me if this seems like a 30,000-foot view, that some of the stuff is obvious. I'm intentionally trying to be obvious, so it's kind of a reminder, and just so you feel less offended if it is obvious stuff, I plan on doing the same thing for our council as well, just because we have revolving counselors, and I think these are kind of important issues, because in our daily lives we very rarely actually sit like judges, and so you guys do it all the time, so you actually are probably more likely to think that this stuff is obvious than some of our other less seasoned folks. So bear with me as I kind of go through this. I'm intentionally being vague because, as a reminder, we can't really speak about specific cases that may be in front of you because we didn't. For one, we didn't notice them, but for two, then in the spirit of fairness, you probably don't want to create a side record where you're opining one way or the other about specific cases. So we intentionally have to kind of stay vague on this. To start, quasi-judicial simply means that you're pretty much sitting like a judge. and you're sitting in judgment of people coming in, and they have rights. And you're asked to sit in judgment of what somebody wants to do based on what their rights are and what the law is. And then, of course, there's usually opposing sides, whether it be sometimes what the applicant is asking for is against what maybe the staff is recommending, and other times it's against maybe what the neighbors are recommending. And so you really are sitting like a judge, and because you're sitting like a judge and having to hear evidence and go through a due process, you have to do kind of what a judge does before the hearing. And let me take one step back and say the way I've structured this, just to make it easy, is I thought, what should you do in a quasi-judicial hearing before the hearing? What should you do during the hearing? And then what should you do after the hearing? And this isn't to say the meeting, by the way, it is to say the hearing. Because in the meeting, some of this stuff you'll see at the end still happens at a meeting, but it's after you close the hearing. And so you act like the judge at the hearing, and then in the aftermath, there's actions that you have to take. You took one of them tonight, so it won't be a big surprise. So before the hearing, right, you have to say, okay, a judge has to be unbiased and impartial, right? And so I think the first thing you always want to ask yourself, and the first thing that we do, is have you read about whether or not you have conflicts. And those are under ethics, Oregon ethics law, either actual or potential conflicts. The easy way that the definition is to understand under Oregon ORS 244.020 is that the actual conflicts are conflicts where you would, or your family members would, or a business that you're involved in would have either benefits or detriments. Right? So you could have a conflict because whatever's going to happen might make you money, but you could also have a conflict if whatever's going to happen, you would lose money, right? Because you probably shouldn't be voting on either of those, right? Because you're going to be biased. I either don't want to lose money, so I'm going to vote against it, or I'm going to make money, so I'm for it. Does that make sense? Those are actual because you would either have a benefit or a detriment to you or your family. The potential conflicts are a little bit weirder in that you could. So, and those can be even attenuated, right? So if you think about what could happen, maybe I own a house in a certain neighborhood, and maybe say something comes in and my house then might elevate my property values, or it might lessen my property values, right? Those are not, it would, but it could. And so sometimes when we're sitting in judgment in communities where we either know people, or we know businesses, or we even have real estate ourselves, or we have other engagements, there's more potential conflicts out there. Those under law, then you don't have to absolutely recuse yourself from, right? Because it's just still speculation. It's just you still have to announce those so that if somebody comes to a hearing and you don't mention something, it seems unfair, right? So in the course of fairness, you want to look unbiased and you want that transparency. So if you could potentially have something happen, but not necessarily, then you want to kind of probe the situation and say, well, I could. Or even appearances is the other thing, right? If you're buddies with somebody for 20 years, you want to kind of make sure and say, well, I know the applicant quite well. We've been friends, but I can be impartial. And in fact, in this case, I'm going to make sure I'm going to hold his feet to the fire, and so I'm going to sit here and I'm not going to recuse myself. So the actual where you would either have a benefit or a detriment, you have to recuse yourself. You cannot vote on. Potential, you can, but you still have to have that conversation for folks, just so you're looking transparent, and so that you make sure, give everybody the opportunity on the record to ask whether or not you are biased or not, if that makes sense. Okay, so that covers our conflicts. So next up, what a judge would ask is, or want to make sure and put out there for the public, is whether or not you've had any ex parte contact. And that in a small town is pretty usual, right? And because you guys will have a body of 7 folks, it's also very usual that somebody's going to have run into somebody at the store who said, hey, let me tell you what's coming up, and and this is what I think about it, and you should hear about it. It's very hard in life to, especially in a smaller town and with so many people sitting in judgment, to imagine where somebody won't try to kind of come up to you and give you some additional information, or you won't live in a neighborhood where it's going to happen, right? Because if this is a cross-section of Canby, there's probably people who live at every side, so somebody's going to be close to the development at all times. The public hearing process asks us to somehow try to make sure that all of the public knows all of the information that you're using to deliberate with. And because of that, you have now this kind of onerous sort of deal where you have to let everybody know there was added information that came to me before this hearing. And it's usually as simple as that, and you just have to give everybody, once you give that information, they have the ability to ask a question if they want. Most people don't. I usually have people say, and despite, those conversations or whatever, I'm going to hear the rest of the information tonight and make a fair and objective vote based on the information I hear tonight or whatever's in the record, right? And so that also is just a matter of transparency and fairness. And also, in some situations, it's a big nothing, right? Like I drove by and I kind of noticed the site, and maybe you'd notice there's a river and trees, and you like rivers and trees, and therefore you just went by the site, whatever. You could imagine where there might be a very explicit attempt to try to get your vote, in bribes, or somebody saying, threats, or somebody saying that sort of thing. So, I mean, the whole gamut of from innocuous, clear to serious, you just have to probe and see whether or not, the information came to you that the public doesn't know about unless you tell them. And then they have the opportunity to ask you about it. Because certainly, if somebody said, I'm never going to talk to you again if you don't vote this way, that, even though you have principles and you would still vote your conscience, you want to make sure and give everybody else the opportunity to see that you're doing that. So out of transparency, Commissioner Mills.
Regarding ex parte,
Yeah.
one of the things that's oftentimes brought up as part of that is folks will mention that are on the commission that, well, I drive by that regularly.
Yeah.
Or I went and visited the site.
Yeah.
And, so I'd like your comments specifically on those two types of occurrences where you've decided, I'm going to go look at that site, and you get in your car, or you're on your bike, or you're walking, you go and you look at the site, and you gather information for yourself.
Yeah.
Okay, versus a case where, I ride my bike by it 3 times a week.
Yeah.
And so,
Well,
any direction on those two situations?
Well, I thank you for that distinction, because there is a richness of evidence, right? And in fact, sitting as a judge in this forum, you guys are not only kind of the purveyors of the rules of the hearing that Commissioner or Chair Savory would be in charge of, but you're also, like a judge would be, the rules of the court, but you're also the fact finder, like a judge would be in a court hearing. So you are, in a sense, like a jury as well, right? So you would want to, if there's a richness to the evidence, I think that is helpful in regard to admitting how rich the evidence is, right? Like, I spoke to somebody for 5 minutes about this at the store while I was buying ice cream is one thing. I spoke to him for 5 hours while they bought me a steak dinner is another. Yeah. You see what I mean? So yes, go ahead and feel free to be as honest as you can about, this is the level of conversation I had, or this is the level of intimacy I have with the grounds. Although ultimately, it's still fine.
The 5-minute conversation can be troubling, though.
Yes.
Because someone can say, you said this, or I understood you to say this.
Yes.
And, you might have just been listening.
Well, and this is why
depending
judges
upon
don't
the
like
individual, it can be a big brouhaha out of that. I've had those conversations in grocery store parking lots where people came up to me and buttonholed me and wanted to tell me a bunch of stuff about what was important.
Yeah.
And, I've had that happen. And, I related it as ex parte.
Yeah.
Nothing ever came of it, but in that case, but
Well, and
I worried about
anything you think that goes to the weight of the evidence is relevant too, right? So, because you're right, in one sense, somebody just making an offhanded comment that says, never let that ferry die, is different than somebody who come here, I want to talk to you. If you let that ferry die, I'm going to do, you know what I mean? And so it's a different report, but it's probably the same effect, which is I'm still going to be objective and fair. And so I just wanted to give everybody a chance to hear that this is what happened. Because you're not really being judged for somebody trying to bend your ear. You're just trying to give a fair process. So yeah, the more helpful and transparent you can be, the better off, because then you build a record that says, I totally, you know what I mean? I'm impeccable in that somebody can't come back later and be like, he said he, only had a 2-minute conversation, but I know those guys went fishing for a weekend. So it kind of protects yourself as looking impartial.
Well, part of it, you mentioned the word appearances, and I think that appearances can be important. You can have, and they all come back to an effect. I'll use the word confidence or credibility of the panel, of the board. If people start thinking we're cutting side deals at the local bar, or having extra conversations by phone or email, the right person could question that and make it hectic.
Well, and what stinks is you don't want to ever become part of the evidence yourself. Right? Like on appeal, you don't want to be the reason number 5 that they're appealing it is because we think they were biased because they weren't sharing this up front and it gets proven. So yeah, I mean, credibility is huge, and even the perception of it is huge, but then, truly showing up in, a written filing in an appeal court can be a little embarrassing.
We have, certain people come before us multiple times. And so over the years, I can't remember how long I've been here, but it's been a number of years. So I've seen, consulting engineers come in many times, and over that period of time, I come to have more or less
Of an opinion?
of an opinion on that person's ability to be forthright. And I don't know where that fits into that. I've found.
Well, I've seen judges, and here's kind of where sometimes we can take our cues from, judge and jury situations too. Like, before I forget, judges will order juries, don't go home and look at the internet on this case. Not only don't go talk to, your spouses or whatever, but don't do necessarily your own research on certain things. So keep that in mind too. But as far as judges and bias, I've seen a judge say, oh, you're on this case, and it will be like his ex-law partner or something. You know what I mean? And so it'll be like, okay, I'm sorry, I have to send this back. You can't send it back, but you can decide, okay, I'm not going to participate. I'm just going to sit here. So if you were so biased, one way or the other, like if you loved them so much you couldn't be fair, or you hated them so much you couldn't be fair, then you'd recuse yourself just because, out of fairness.
It isn't, in my mind, because I have somebody specific in mind, but over time, I've come to understand that this one consulting engineer is very detail-minded, has been transparent, and he's very good. He makes a really good presentation. And so as time has gone on, I find myself listening to him, always listen to him, and, but come to favor what he says. I don't know him personally. I've never seen him outside of this situation.
Well, it's kind of tricky though, right? Because when we created a jury system, a lot of those Federalist Papers, some of the arguments for those were, jury of your peers was something to the effect of, well, if you have a milk dispute between two farmers, if you have people from that area, they're going to probably know about that dispute and know about that lifestyle and know about how farmers should treat each other in contracts and stuff like that. And so some of the justification for people sitting in judgment of other people was you kind of knew the people, you kind of knew the lifestyle, the situation, so you kind of had baked in some kind of understanding. It's funny that now we almost try to, inoculate ourselves away from any sort of humanistic understanding. But if you're weighing evidence, it's really hard to not say that person's been spot on for 20 years, and he seems to be making sense. And I'm not sure we would honestly ask you to not do that. The trick is to try to keep your mind open enough that if the other person makes better arguments, that you don't refuse those and go back to the other guy just because you like him. So, does that make sense?
Yeah.
Yeah, because I think when you're weighing evidence, you are being a human being still, and you're still applying common sense and reason. That, like, our whole system's based on that. So, those to me smack of common sense and reason. I would choose those over, robotic selection of rule boundedness. So, if that helps, yeah, because you are weighing evidence. And you know what I mean? But what you don't want is the snake oil salesman, putting some shine with some emotional appeal, overruling the common sense and reason too. So just be aware of that, I guess. Which gets us into some of the reasoning behind ex parte, and then we can go right into the hearing, because that kind of gets into that hearing idea, is clearly we want to just have a record, give notice to everybody, give people an opportunity to inquire, because people might not have the same perception that you guys have, having sat here done this quite a bit. So some people will be like, what do you mean he's your cousin? You know what I mean? Like, oh, you guys are crooks. Well, if you air it and you put it on the record that you aired it, and you can even explain, like, look, he's my cousin, but that doesn't mean anything to me. I do this all the time. I've ruled against my best friend. I've rules. You know what I mean? So it gives an opportunity, if somebody is going to inquire, to kind of, put everything to bed beforehand. So it is really for the process, and as Commissioner Patton said, to make sure that we, and Mills, our credibility kind of stays intact. So for the due process, and then it gives them also the right to rebut, because maybe they do know. Maybe it turns out that your cousin and you are thick as thieves, and you know what I mean. And maybe holding your feet to the fire isn't the worst thing after all. So, and then you just want to make sure, if you have a ton of ex parte contact, one of the checks and balances too is, if you had that 5-hour steak dinner with somebody and they really, told you everything about the case, how do you make sure that you back off that and say, I didn't make up my mind in advance? Because you really could come in here with a very good idea of how you're going to vote if you spent that much time. Because why do you need hearing then, right? So part of the quest is to say, even though that interaction was bigger than the hour we gave them up here, I'm still going to be fair and impartial, and I'm still deliberating using this information here, if that makes sense. Cool.
For me, what it comes down to is, the last thing I want to do is have something I say or do or don't disclose not only discredit the process or this board, but also open the city up for liability that it doesn't necessarily need. Because if it happens on this one, well, what other ones did it happen in? And then it opens up this whole can of worms.
Yeah, and that is true. I mean, the more impeccable we look, the better off we all are, and future boards too. So, because you could see where if corruption got in, for an era, it's really hard then for basically a generation to try to dig your way out of it. So my dad still talks about, I went and worked for one of my first lawyer jobs was working for the Lane County DA's office. And he was like, those corrupt guys? And I'm like, that was 3 DAs ago. So, we live and die by the people before us too. So it is a good idea to kind of, keep carrying torches that are good torches throughout so that, future people get the benefit of that too.
Yeah.
Okay, so during the hearing, so, after you read your script and you go ahead and announce why you're fair and unbiased and impartial, and how much information you've gotten ahead of this, then, it's the during the hearing really is the meat and potatoes of not only the record, right, and making a good record, not only to protect yourselves in the ways that we were talking about with credibility and making sure you give a good hearing, but you are talking about the rights of individuals, and I think you're all on this because you believe in land rights for folks and people's right to be able to do things, but also the right of the city to be able to regulate that in a fair way that treats everybody the same. So that sort of balancing act is the reason why we go ahead and we have the same process for everybody. And so the legal rights of property owners are, clearly to use their land, but then it's also to go through a process of applying for that in a manner that everybody else gets. So the first is the substantive kind of land rights of you own your land, and therefore you have the bundle of sticks of rights, if you ever hear that. And then the other right is the city is set up to always try to give the same level of hearing and due process and processes to every single applicant. So you kind of want to be consistent in that regard, and part of that is because you might be appealed, and so you want to make sure that everybody was given, I'll give you a good example, if the applicant gets 45 minutes to talk, but any opponents get 1 minute, you know what I mean? Might get appealed on that, right? Or the last applicant, you had 3 hearings that night. The first applicant got 5 minutes to talk. The second one got 20 minutes to talk. And then the third one got, you're back down to 5 minutes to talk. That's going to look a little weird too. Those are things that are pretty obvious, but so that's why we do things consistently. And just make sure that you're actually doing what you're saying you're doing, which is, if people are sharing time, you're letting them, not cutting them off if they are going to be sharing time just so you don't get appealed on that. Because oftentimes, and it's kind of sad, but oftentimes a lot of the cases that go to LUBA are just procedural. And so you just want to actual issues that have to do with your code, because LUBA oftentimes defers to cities to interpret their own code, especially if there's ambiguities. So just keep that in mind. So you want to make sure and always get the same procedure. Chair Savory.
Yeah. Typically, the applicant has 15 minutes and to state the case, then the people that follow after that are pro this side get 5 minutes.
That's cool.
Opponents, 5 minutes. And then there's 10 minutes of rebuttal. And, ever since I've been, we've only had 2 instances in all the years I've been on this commission that we've actually told people you have this much time, and at the end of that time you're done. And it's only because there's so many people, and I get tired.
Oh yeah.
But otherwise, it's my feeling is that it should be pretty open-ended. People should be able to say what they have to say, and there's usually not that much. It's more of a discussion than it is, a strict process. And
That's fair.
Is that fair?
Oh, yeah.
Okay.
Well, and I think Canby has a kind of, as long as I've been here, which isn't as long as you've been here, but it's, coming up on 10 years. I think we err on the side of collegiality and on inclusion, right? So I think if people want to have their say, I don't see most of our committees don't want to cut people off. And unless, like you say, the galley's full and everybody has a yellow card, and then, it is what it is, right?
Yeah.
I mean, you can't be here serving people till 3 a.m., so, and those are good decisions that fortunately you don't have to make too often, but those are valid. I think everybody in the room they want to talk, but I'm not sure they want to have everybody else get unlimited time before they talk. You see what I mean? So I think the whole audience is going, okay, I just wish I could get my 2 cents in, and then, maybe not have to hear, some other guy talking for 10 minutes about it or whatever, so.
Well, isn't the problem with that, though, that, when that case comes up where we have a room full of people and we limit them to the 3 or 5 minutes or whatever to talk in this current day and age, whereas, in the previous meeting, there was only 2 or 3 people, so we let each one of them have 10 minutes.
Yeah.
The problem lies is that they can say, well, hey, in the last 1, 2, 3 hearings, you didn't have as many people, so you let all those people talk for 10 minutes. Why can't I talk for 10 minutes?
Yeah.
And that opens up essentially liability for us to then have to say, well, I mean, is that true?
It is somewhat true, except, there's kind of phrases that in hearings, judicial efficiency is one that comes up a lot, and you do things sometimes for judicial efficiency that you wouldn't otherwise do. So a galley full of people who all want to talk, I mean, judicial efficiency is going to win over whether or not 2 weeks ago somebody got an extra 5
Right.
minutes.
Okay.
If that makes sense.
I've had cases where I've chaired meetings where people were brought in by the busload.
Yeah. Yeah, so you
Okay.
can't, I mean, you're,
And you have to go through, and you have to, adhere to it. And after those meetings, I took some heat from some of the from some of the other commissioners that I should have been more harsh with cutting people off. And I tended not to do that.
Yeah.
And I'm with Commissioner Savory. I'll just tell you, I feel like when we talk about the equitability of this, where applicants come in and have pre-meetings with staff, and staff presents reports with the applicant's graphics and statements and support of those things, and opposition comes in and they get 3 minutes.
yeah.
So I think you have to be real careful
Yeah.
in terms of cutting off opposition, because that may be the only chance they've gotten to say anything. Whereas the applicant, correct me if I'm wrong, Don, please, has had far more opportunity in contact with the city to figure out what they think will work and what will be acceptable to the city. And, and appearances to me is they have the support of the city at that point when the city's making a presentation, where at the end of the presentation, the applicant says, yeah, what they said, which I have trouble with personally. I don't think we should be doing that.
Well,
But
I can say part of the reason we set things up the way we set things up is we try to give the person who has the burden of proving whatever they're trying to do, the kind of the first shot and the last shot. That's kind of how our system's always set up.
Yeah.
So, and I think that's also why they have the burden of putting in the production too, right? Like putting all the evidence in the record, and so it's a different level of evidence, right? If you have to put in all the maps and all the discussion and all the kind of technical points, and then somebody else can get up for 3 minutes and just hate your face. You know what I mean?
Right.
So there's that, but then people can also bond together and share their time. So you can say, could you have not brought in a friend, and then you could have talked twice as much. So there are ways of kind of, mentally picturing, okay, well, this person had to go down the road of what the code was, how they met it, where they, were asking for any sort of variances or whatever to the code, and then kind of have their arguments, get everything in, and try to address any questions you had. And that's a high burden sometimes. And so, you can feel maybe for people who are in opposition, and the one thing I will say is, I've seen where people will say, okay, we can't be here forever, folks, so I'm going to give the opposition a total time of 40 minutes, figure out how to break that up. And some people will go, okay, I want to come up only for 3 seconds so that I get standing so I can be on the appeal, if that makes sense.
They'll also yield their time.
Yeah.
I've had that happen where
Yes.
somebody, I yield my time to 1,000 friends. I yield my time to 1,000
Yeah,
friends. I yield my time to 1,000 friends.
Well, and so that
And
can be a very powerful thing. So,
Well, that's-
so
that's-
if you give everybody 10 minutes, then suddenly 1,000 Friends has an hour and a half to yell at you.
That's
So-
right.
So that's the other kind of,
But that's where the power of
guiding or
numbers-
balancing principle is.
That's where the powers of numbers comes in
Yeah.
against judicial efficiency. You say, well, we're going to limit them to 2 or 3 minutes each. But if you've got 50 people in the audience and you have some skilled orators and code knowledgeable people and they're organized, they can be a very effective,
That's
you
very
have to,
true.
you have to really
Yeah.
pay attention. And I'm not saying we don't pay attention.
Yeah.
That's not my meaning, but it can
Yeah.
get pretty good, pretty
I don't know, some
entertaining.
filibusters, your eyes start to glaze over, right? Because
I tend to think that works against them in a lot of ways.
Yeah.
You know.
Well, and you guys are good because you're more focused on the code type of board too. Some boards are more inclined to give credence to emotional arguments, and I don't see you guys as being that necessarily. So, I think people who, if they get wind that if they come in and squeak enough, you will, actually bend to their will, then you'll get more people coming in making emotional arguments the subsequent hearings.
I think in our case, just the opposite occurs. I think that we have a reputation for, here are the rules. I may really like
Yeah.
what you're saying, but I'm sorry. It doesn't
Yeah.
fly.
Well, and that kind of goes into the idea of being principled, which is the approach that's not clouded by either political or emotional decisions. And like I say, I'm probably preaching to the choir here, but that is the area where if you're being a principled jurist, right, somebody sitting as a judge, you're going to want to know what the law is and what the facts are, and please don't, cloud it too much with either irrational or emotional or political arguments. Let's talk about the facts, let's talk about how it applies to the law. So, and like I say, I think you guys are pretty darn skilled at that. So, and then it's good for you guys if you're focused even on the say the key approval criteria, that you're still maybe the area where people can then get to you guys, right? Because I think some people say, well, if I'm just the facts, if I'm Joe Friday and I'm just the facts and just the law, then I'm, not only going to be not well liked, but nobody's going to trust what I do. There's areas where you guys can use some of your discretion, and that's kind of within there's areas within the approval criteria when people apply for variances, or when people, and where it doesn't say shall, it says may. And so in those areas of discretion, and I think staff usually kind of highlights those things for you, that's the area where you don't have to be Joe Friday so much. Maybe you can just be like, well, okay, so we're given the discretion, it says may, so actually, all of us as a group can kind of figure out what should be in this case, not just what must be. So, and that's kind of the fun parts, and I think you guys dig into your packets enough to kind of know, okay, this one we can actually have an opinion on and decide against, because we're not being told we have to just follow the law in that regard. So, I'm trying to see what else. During the hearing as well, and this is what's kind of interesting. You guys don't do this, I don't think, at all. We have certain folks within my tenure here who have texted while they're on the dais, or when Zoom was happening, it looked like people were doing research over here, and I know sometimes our packets are on our computers.
Yeah.
And I think people get confused about that now too, but, just even the appearance that like, what are you doing? Are you having a full on-site conversation at home and then coming back on your Zoom? Those are kind of newer versions of that, the issues of, the public has a right to know what you're deliberating on, clear up to if you made a cell phone, little snarky comment to, Commissioner Mills is over there, and I'm like, what was that guy all about? You know what I mean? If somebody, and I know that Oregonian used to do this more in the Portland area, they would say, I demand a public records request on what that was because it happened during the meeting, during the hearing, and I want to know what the information was that was shared. And so, those are things to be careful of too, is that we don't,
Have you ever talked to the body that you're talking about that does this stuff?
Yeah, I have.
They still do it.
And then the other, maybe you heard Wes Lynn. I think the kid ran and now is one of the counselors up there. But that kid Rory, he I think did a public records request of all the notes of one of the city councilors up there, and he got them. And some of them were, gibberish, and some of them were, I hate this person, ugh, and some of them were whatever. So, I mean, you do have to be careful, too, that some people are a little bit feistier about what evidence they think you're, getting from other people and what even some of your deliberations are. So just keep that in mind. But during the hearing, clearly, we want to make sure that we have sunlight on the process and that there's transparency. I always try to warn people, then, make sure you're paying attention and not really necessarily, passing a note along to somebody else. Sometimes those things are innocuous. It's like, here, remember on page whatever, for when we're going to read the
I passed the note
motion
at the
or
last
whatever.
meeting.
Yeah. No, and that happens. And in all fairness, if somebody says, I want to see what that is, you show them, right? And it's just a note that says the motion's on page whatever when you want to make it. So that's fine too. But so sometimes there's a cure to what you're doing. Here, I'll let you read it. I've actually seen people demand to see, if, and this was in the criminal law, but like the prosecutor comes up and hands something to the witness, to look at, and then the other person demands to see it because I want to see what you're telling them to say, as they're up there or whatever. So those things are all kind of fair when you're trying to do a hearing that the record is trying to be as sunlit as possible. So that's our attempt.
I think that is a very important point that you make regarding, conversate, like if you have your phone out or if you're doing things on the side. In my opinion, as the city continues to grow and more of these hot button issues start to come to light, and with the litigious nature of society ramping up more and more, it is becoming more and more likely that we could find ourselves in a situation where someone says, hey, you had your personal cell phone out doing something with it, I want to see that. And as far as I understand, we then have to do that. We have to comply.
Yeah.
So I think that is something really important to drive home, is that, slowly gone are those days where it was sort of willy-nilly. We are heading down a much more strict path, and we have to be careful.
I think so. And to that point, even, I recall before Zoom, people were asking, hey, can we just telephonically appear, in case somebody's off and away? And you would know about that, right?
Yes.
And the answer is, that could be allowed, but I would want some assurance if I was appearing in front of you. Whoever's on the phone, do I have their undivided attention? Who are they? Are they talking to anybody? Are they researching anybody on the internet while they're also on the phone listening, right? So, and that's just because I'm kind of like that, right? If I were appearing in front of somebody, I would want to know but those are valid concerns, and Zoom created a host of those too, right? Because you are at home, and some people, they're probably eating, so they turn off their camera, but they also could be, looking up stuff or, doing something else. And so, those issues kind of open up in a hearing setting, kind of a mess of what could be evidence. And nobody's really held our feet to the flame quite yet, but they could.
Yeah.
And then that would just be potentially embarrassing, depending on whatever was happening at the time, right? Or whatever were in your notes or whatever it is. So just keep that in mind. And then what else are we at here? Yeah, I mean, the record itself and the fact that the record's being recorded and the fact that it matters to the applicant and it matters to the opposition and it matters to the city and the history of things, those things kind of all keep us honest. And it also is, it's nice we have television here. A lot of the court stuff I used to do was all audio, when I first started out in criminal law, and it was all just what you said. And so you had to build a record. Back in my court days, I would say, oh, and is the person you witnessed do whatever in the room? And the witness would only say, yeah, he's right there. And then I would have to say, let the record reflect that he pointed at the defendant, right?
Yeah.
So it was all audio. I mean, now we have some visual too, but I just bear in mind everything that you're doing and everything that you're listening to and everything else is truly now part of a record, and that keeps us honest.
So I see where it says no independent research, which kind of makes sense, but in a lot of instances, that doesn't make sense, I got to tell you. So we have coming up, we're going to have, at some point, something to do with food carts.
Yeah.
And this will be the second time that this has come up
Yeah.
for this body. And the first time we turned it down. This has been a few years back.
Oh, quite a few, I think, yeah.
And, but it's nothing has come up before us yet in a sense, except we're going to have a discussion.
Yeah.
And so I don't know whether I will have to recuse myself or not, but I was at one of the local establishments here in town.
Yeah.
The subject came up with the owner of that business.
Yeah.
I asked, what do you think?
Yeah.
And so,
Oh, and that's fine. I mean, part of that is you can't unring certain bells, right? Because, again, people will accost you in the parking lot. You know what I mean? And so I guess the best you can do is try to be honest and open about it, and then I think that lends towards you're a more fair person anyway, right? Like you would say, I've had conversations with people I respect, and I know a lot of reasons against these things. I'm going to try to be fair and impartial. But I think the no research on yourself is more like, and there's ways to do this too, and I can even get into this with experts, because it's where a lot of times an applicant has the right to bring whatever study or expert that they brought. Opponents would have a right to rebut that with their own expert stuff, right? But if you went out and you sought 5 other expert opinions ahead of time, that's kind of a level of unfairness in the process, if that makes sense. So it really is kind of, or somebody could be wrong, but you bring their opinion in, like you went out and you took a poll of, everybody who lived at a certain area, an informal poll, to see if they even liked it or not. You see what I mean? That would almost be like unfair level of research on a topic. And then you would, of course, say it, and then it would be this weird sort of, well, what does that even mean? And how can we question your poll? And, are you a pollster? And, are there contrary polls? You know what I mean? So it almost puts more of a burden on the applicant to now respond to something you've done who you're supposed to be fair and impartial. And so you almost have to trust, if you trust the process, you have to trust that any opposition will do whatever they do. They might have experts, they might take their own polls, they might bring them to you, and then you can consider that evidence, but don't make the evidence yourself as the judge, if that makes sense.
Well, couldn't it also be like we get our packet and it says, this particular engineering group is part of this, development?
Yeah.
And we say, oh, you know, that name sounds familiar, and then we Google and we find out, oh, well, they did this one over here, and they did that one over
Yeah.
here, and there's this negative publicity about them, and da-da-da. And then we come to this dais and are like, we already have a preconceived bias that, whatever they may be telling us, I mean,
Yeah.
it could all be
Yeah, yeah.
fine.
Yeah.
But we have a bias against that person because we've done that side research and have made up our decision that maybe they're not shooting straight with us. Is that
I think that is shaky ground, because for one, you don't know, you probably didn't write out all the different things that you did so that it gives the applicant a chance to even rebut maybe what information you were getting. You know what I mean? So you're not bringing the sites that you looked up in the opinion, maybe, you know, articles that you read and all that to give the applicant
Yeah.
a fair shot at rebutting that too.
But
Because-
that's like the don't do that research.
Yeah, don't go the deep dive on
Yeah.
that particular, although, here's the thing. If you do this long enough, there are ways to battle experts with, you know, learned treatises and things like that, and like common knowledge and things like that. And so you are sitting there, I think part of it is if you're just a pure judge, you make the you know, proponents and opponents make the record, and then you use the evidence that's in that record, and you just sit in judgment on that as it applies to the law. That's like the purest form of hearing, so that you're not creating the evidence yourself. But it's going to be very, very hard for 7 people to not know something, you know, and all you guys have levels of expertise, and then you also have a lot of experience. And so we can't, in fact, we like having people with experience on these panels, and we like people with a head on their shoulders to be on these panels. And so there is this sort of fine version of, well, going forth and trying to find all negativity about something could be a problem. But if you've been around long enough, you've seen certain experts come in and they always are either snake oil salesmen or they're always, you know, altar boys. It's pretty hard to not have that weigh your evidence a little bit. So if that helps.
Just a comment, Chair Savory, since there'll be a work session on August 4th, Joe, just a comment on what if the commissioners and counselors in those sessions direct staff to areas that they are interested in as part of that dialogue and discussion?
Well, and I think you guys can decide, I mean, if the record is supposed to unearth, you know, all the evidence and what you're deliberating on, it's going to be really hard to know what's in everybody's individual head and why, and whether or not there's, like you might be the guy who's really good at researching this expert or whatever, but somebody else might not even trust your research. You know what I mean? So then it becomes this whole sort of like, well, every time he looked up something, you know, he came up with some harebrained idea. You know, you see what I mean? So, I mean, there is this dangerous slippery slope of like, then how do we even make decisions anymore if the whole universe of all information is at hand, and how we filter it through our own heads and then spit it out makes it kind of, although somebody could probably argue that if we all did that, we would all come up with not only better answers, but probably the same answers, right? Because some of the other arguments for juries is that as a group with different varying levels of expertise and different varying experiences, you pretty much come up with the right answers. You know, except for like really outlandishly either political or emotional issues, like juries usually get it right. So it is kind of interesting when you have a panel, like together you guys are stronger than individuals usually, so if that helps you. Because I'm not saying you can't be a learned person that knows things and then apply those things using your common sense and reason. But to be fair to an applicant, I think you want to put aside what you know and maybe give them the opportunity, or ask the question then, well, I heard this. You see what I mean? And give that person an actual chance to answer and rebut it or whatever, as
Sure.
opposed to just being like, okay, and then after the hearing's all done and they don't have any more evidence that they can add, then you start adding your own. That's unfair.
Sure.
Okay, if that makes sense. So, and then, so those are, the other thing is, for public relations pieces, I think you probably wouldn't necessarily want to be overly zealous on one particular applicant in that regard either. You see what I mean? Because not every time are you going to chime in about whatever that expert was. And so, and I think part of that process for making things look consistent too is because every time you don't want to have to do a deep dive of, 1,000 pages of extra research beyond the thousands you already have to read. You might want to spare yourself and also look like you're giving the same sort of level of hearing to everybody, if that makes sense. Because sometimes you might have more energy and so fine, I'm going to go a deep dive. But if you're not going to do a deep dive all the time, maybe you realize too, part of a fairness process would be, I'm going to do the same level of prep that I do for every meeting or hearing, if that helps. The closing of the hearing, and this is kind of a stylistic choice for the chair in a way, but there are ways in which if you close the hearing and don't allow any more evidence, but then you start asking questions of, say, the applicant or even the opponents, then that is more evidence.
Yeah.
And then how do you cut that off? Or how do you consider that or make it known that you aren't considering it? You see what I mean? So just be careful with that.
And we do that frequently.
Yeah, we
Yeah.
have
And we do it mostly for clarification purposes.
Yeah.
So should we leave the hearing open?
Well, you can either leave the hearing open, or you could say, actually, I'll reopen the hearing so that we can get that answer from the applicant. Because I've seen where people go back and forth in the discussion, and then they find out, shoot, there's 3 or 4 good questions that people were thinking about that were never answered. And if you want to give them an opportunity to be heard, or sometimes the applicant will go, like, actually, I would like to actually address that question, because that sounds like a good one, and I missed it, and I don't want to lose out here. So if that's the case, you can just reopen. You could say, I'm going to reopen the hearing to hear this.
Well, we don't, that seems like a fairly arduous,
Yeah,
thing to do when you're really having a conversation. And
Yeah.
and I think that it goes back to what you have written down, your equal time and opportunity. So if the applicant says, oh, yeah, well, I can answer that question after you've already closed it.
Yeah.
And the opponent goes, well, what about, so we have a conversation.
yeah,
I like to have, everybody be heard.
yes.
And unless they get abusive, which has never happened, by the way.
And that's good, too. I think that's kind of the Canby way and pretty unheard of, because people are special sometimes. And so I think I'm actually of the same mind that I think most of our boards hold a kind of a level of kind of respectableness themselves, that people don't come in, they know they're not going to score points by being way over the top or super aggressive.
The only time that has ever occurred in all the years I've been on there was about this building right here.
Oh, yeah, yeah.
About the library.
Versus, the other library, yeah.
And that's the only time that has ever been an issue. So.
Well, that's good. So it might not be the worst practice to just say, well, I'm going to close the public hearing, try to have that informal conversation. If it seems like evidence that just wasn't anywhere in the packet and it wasn't anywhere in the original testimony,
Got to open it.
then you should open it and say, okay, that sounds like new evidence that we haven't heard and we didn't see here. I'll open this back up for you to hear it, and I will then allow for any rebuttal if people want to rebut that.
Well,
I
that's
think
what-
that's the fairest way to do it.
That's what my next question, that's what my question was gonna be, is if we close the hearing, there's more questions, open the hearing back up.
Yeah.
Does that effectively restart everybody's time?
No.
All over again?
Well,
Okay.
I think you have to just treat it as, because everybody got their time. And so now you have to consider a construct where maybe it's more fair. So because we overheard that, I'll give somebody 1 or 2 minutes if they want to try to rebut this, if that makes sense. Because I do think for a fair process, that would be a good way. The other thing is, because we talked about at the end of a hearing, whether or not somebody, some of the lawyers that I talked to that do a lot of land use, they try to read you guys, right? And they're like, huh, and they think if it's going a little sideways, they'll start, trying to ask for like, can I have an extra week to like get in some extra evidence? And, so then there's that either, do you allow for more evidence, but then you give an additional week after that evidence comes in for any opponents to rebut that? Or do you just set it over to the next hearing to have just a little tiny mini hearing to see if, the evidence, how you regarded the evidence or not? You kind of effectively have to set it over anyway. If you allow for more evidence, you're all going to have to read it and make a decision on it later anyway, right? So the long and the short of that is that it's a set over for you guys and your decision. The real question is whether or not you want to reopen testimony or whether you just want to, fine, I'll give you a week to get in whatever it is, and then I'll give the opponents a week after that to rebut, and we'll read it offline. It'll be part of the record, and then we'll make our decision next, meeting or whatever, so, if that's helpful. Because those are kind of, at the end of the hearing, how do you, especially if you're curious or there really are burning questions and they didn't answer them. Some people would be like, well, it was your burden, you didn't make it. Other people, it sounds like, and you guys see more of that stripe, I want to give everybody a fair chance, and I don't want to have to keep coming back to hearing, because if they want to use their land, they're going to come back, so you might as well give them the opportunity to kind of be heard. If it's 5 more minutes, 10 more minutes, great, you know what I mean, versus having a whole new hearing or whatever it is, or even appealing your decision to not let them be heard. So those things are good things to keep in mind. And then, so we'll go to the after the hearing now?
Joe, could I just add one
Yeah.
thing?
Oh, yeah.
Commissioner Mills raised a really excellent point about equal time. And just an observation, and can be, I think part of that is an educational process for folks, that I think the perception is that is your only time, the 3 minutes that you got or the 5 minutes that you have. The reality really is that if people comment, during the public notice period, we will address those in the staff report, and we'll address those specifically. Canby is also fairly robust in its process, requiring neighborhood meetings for every application essentially, which I think also gives a pretty substantial educational piece to neighbors. I think the challenge is people not understanding that they can write in comments, that we will address those comments. Also, the Planning Commission, this body, I think really is a fairly unique situation for jurisdictions that are comparative. Many jurisdictions have just a hearings examiner process. And so I think
And an appeal out of that to the
exactly,
To the commission,
which
yeah.
is very legalistic, and I think this is much more in terms of, addressing character and kind of the community. It's really more in line with that. I think you're, this body. So it's not to say that I'm arguing against that people are giving adequate time. I think we need to give adequate time, but I think some of this is education in terms of getting the community to understand better that there are these processes that, if they're ahead of those or they're involved with those, that actually does give them some greater equal standing to an applicant.
I guess what I always come away feeling, and this is not just here, but is that the neighborhood, the people in the neighborhoods where the change is being made don't understand land use law. It's not their job.
Yeah.
They might know what they're zoned as,
Maybe.
Beyond that, maybe. Beyond that, they're not going to know anything. They're not going to understand what the comp plan is, what the comp plan land use designation is, or how that land use designation overrides zoning. I mean, it's just, and the developers understand that. And public meetings are conducted by the developers, not by us. And when you read the records, there's a lot of things that just don't go answered. The questions are raised, and you can see there's probably sympathetic nodding, but nothing happens. Then it comes here, and you'll have, cases where people are very upset. I mean, I've been in a lot of meetings, not so many here in Canby, but I've been in a lot of meetings where a lot of people are very upset, and they don't agree with what's being done, even though it all complies with code. And so.
So education piece.
That's a case where, I don't envy staff, but to me, and I think Commissioner Patton has mentioned this, that we all probably need to do a better job in these processes of trying to make sure that the affected people, the people most immediately affected, have an understanding or a kernel of understanding of what is going to happen and why it's happening and why it's allowed. They just don't understand. I mean, some things will just bring the hair up off the back of the neck. Mention triplexes to the chair here. It's a conditional. It's allowed by conditional use in our current code in R1. Okay, so whether we like it or not. So when we're there, then we have a hearing for that. Then we have to adhere to the code, right? I'm asking that question. It's kind of a loaded question because I don't always believe we do.
If it's conditional, right, then there is a question about use and precepts of good planning and
Compatibility.
yeah. And so, I mean, there are areas, and this kind of gets into maybe the next, just so we can segue, is that so you have a sticky situation like that, right? And you might feel one way about it, and you might feel one way about it, and they both might be negative, but they might be different.
Yeah.
And then somebody might be positive, but different from your positive, and then somebody else is kind of on the fence.
We've had exactly
and
that.
So when we have to write the findings of fact.
Good luck.
Yeah, in order, there is no plurality reason, a majority of you don't actually feel the same way about anything. And so when you guys are fact-finding and deliberating on the record ahead of us actually codifying that, it's super helpful to go around and make sure that people understand, okay, the reason we're not allowing that condition is because of compatibility. You know what I mean? Like that 5 people or 4 people will say, yeah, compatibility, I agree with that. You see what I mean?
Yeah.
So that it isn't, well, I think compatibility, he thinks he hates the look of it,
Well, I think we make attempts at that.
Yeah.
The chair always encourages us to state why we're voting the way we're voting, for
Yeah,
example.
that's good.
So for the record, you can
Yeah.
say, well, I'm for it because of this, or I'm opposed of it because of this and this. And that'll give you a flavor for writing the record and gives the public a sense of the commission. And why we did it. And that's where you can see the differing opinions that generate the decision.
Yeah. And if you test the wins a little bit and you realize maybe you were counting votes and you're like, shoot, we only have 3 people who really hate this for density reasons and 3 people that hate it for compatibility reasons. And you see what I mean? You might, some of the compatibility people might be like, well, don't you also hate it for compatibility? And, the density people might say, and don't you also hate it for density? And so we have at least we know that a plurality feels maybe for both, that for both those reasons, we won't allow that condition.
Can I get 2 cents in on this
Yeah.
triplex thing?
Yes.
Because I have a real problem with it.
Yeah.
Sorry, Larry.
One of the reasons I have a problem is we spend all this time in the city of Canby developing a plan, and then you got a bunch of nerd heads in Salem that come around and tell you got to do something different.
Yes.
That's been in the code
That's
since-
what you're paid for.
But that
Sort of.
Because
Yeah.
I don't like that.
Yeah.
I really, really have a hard time with
Larry, that code change precedes that Salem decision. That's been in the code for 12 years, 15 years?
Well,
It's been
they
in code.
didn't say conditional, they said.
No, I know that.
Yeah.
The new decision is it's not conditional, it's allowed.
The
flat-
2001
outright.
and 2003 stuff is a bear for everybody, and it's because they decided with the supermajority is, that they were going to be supreme for everybody, and it's a lot of jurisdictions are not happy.
Just to shed a little light on that, I think there's perhaps some misunderstanding about those as well, those House bills. House Bill 2001 is essentially, you're allowed to put a duplex on a single-family residential lot. That's essentially the code. That's a law that's in place now through the state legislature. House Bill 2003 is really focusing on housing needs globally. It's not mandating what the city will do to address that, but it does get into demographic analysis and population and cost of housing and related to demographics and affordability. That is to come. That's forthcoming. Back to the question, if that is in the code as conditional, that's discretionary, which this Planning Commission has, this body has the discretion to look at that in a way that's different than clear and objective standards, which if it was a permitted use. So that does give the Planning Commission the discretion to basically say exactly what Joe's saying. Is it compatible? Is it not? Those are unique criteria that are not clear and objective like a permitted use in a zone. And I think you're seeing, as the community grows, there are challenges with even those situations where it's not conditional, it's permitted, and it's not happened in this community before, and it's in areas that people are complaining about compatibility, but it's allowed outright. There's not as much that can be done in those circumstances, because essentially it meets the code.
Well, I think that a conditional use, I think when we were going through the code, remember we were turning down the triplex. This isn't a duplex, but we were turning down the triplex, but we had before allowed them. So I think that's why we changed it to a conditional, because they'd been allowed before by a different.
And the conditional use criteria is pretty tough.
It's a lot about compatibility, and, it does have some teeth in it that could be used. And again, I think back to Joe's point about going around and querying each commissioner for staff in particular, so that if that is the direction that it's determined to not be compatible, that it's defensible as it goes up through the process. That will be important.
And so, if you make the good habit of going around and always saying what you feel and why you feel that way, I think that's great for the record. And then the other thing is so that you can other people can buddy up too, right? So you'd be like, yeah, that's actually a good point. I'm with that idea as well for the findings and final order kind of thing. So it makes it easy because you don't necessarily have to repeat everything somebody says. You can just say, I agree with that. And so now it sounds like you're all in this, at least a majority of you are feeling this, that, and the other thing. So we can write them all up and have a stronger final order. So the other thing is just when you're weighing the evidence, I think you do have to be careful, and this goes back maybe to that expert stuff. I have the example here of the battle of the experts. When you're weighing evidence, I think you want to make sure that, and this maybe sounds obvious when I say it this way, but you don't want to rebut evidence with non-evidence. So you can't, if there is one expert in the room that opined something, I don't think you can say, but I don't believe that person, and that shouldn't outweigh the evidence entirely, right? Because when LUBA looks at a record, they will say, was there, evidence as to this sort of study? The fact that you don't totally trust the study for whatever reason isn't counter evidence, if that makes sense.
Very often, expert testimony is challenged.
Yeah, but
Oftentimes by the opposition, by
Correct.
saying, well, you can't build on the hillside, it can't be engineered. Well,
Yeah.
probably can be engineered.
Yeah.
You know? But
Well,
no,
and
it'll fall
so-
off. Well,
I think
So
most
just
of-
rampant skepticism, you want to not necessarily, weigh at the same level as experts.
well, that's what I mean. you know,
Yeah,
So you
yeah.
have to look at that, and then the interesting thing, when you get opposing experts.
Yeah, well, and so there you do have to decide which one you trust.
Well,
That gets really
I think the most obvious example of what you stated there was all the traffic. I mean, that's a big thing for us, and the people that might be opposed to a particular development because it's bringing in, 1,200 new car trips per day,
Yeah,
and the experts, which the city has, said, oh, no, that's fine. And you add that 1,200 onto the 1,600 we just had.
Yeah.
And then 500, no, they're all fine. And the people that are affected, your
Yeah.
Joe Sixpack out here, is going, that makes no sense.
yeah.
I don't think it makes any sense. And it's the one thing that I am always skeptical. I have a bias.
Well, you could ask that question too, though, right? You could say, did your study take into account, we just did 1,600.
As Don can tell you.
Yeah.
We discuss that continually with every big project, whether
Yeah.
whether it's Columbia Distributing or Stanton or Caruso, they all added thousands of car trips per day. Nothing has changed in terms of the capacity of 99 or the side streets or whatever it is. And yet they're telling us, no, that's all fine. And my lion eyes are here to tell you that that's just not true.
Yeah.
I mean, would you agree with that?
Glad you asked.
Well, I mean, I'd sit there and I'd
I
go,
do agree with it, and not only
Yeah.
that, the people I was talking about in Salem are talking about putting a toll on the freeways. That leaves only 99E
Yeah.
open.
yeah, and
Then what happens?
Well, and then the railroad has a nasty habit of stopping trains every weekend too, right? We're hopefully trying to kind of do our best to make people not only behave, but,
unless you find a way to make 99 one way this way and then find another way to go the other way, one way the
yeah.
other way, nothing's going to happen. There's just not the,
yeah.
Well, I
Go ahead.
I was just going to say that the one case where I've had developments curtailed was when they were within like a mile and a half of a state highway. And the state said, no, you can't put that many cars on this road. It's already at level of service F. And they said no, and we only allowed like half of the development at that time. And I don't know that that's changed yet.
Well, 99's a special bear too because it's ODOT, and so,
Yeah, this was too.
yeah, and so they do come in and control things to a certain degree. I mean, we'll see, we're hopeful that they even like our Walnut Street extension, for instance, and where it's going to pop out and all that sort of thing. And they've given us some assurances, and that's only one, way in which we have to deal with them. But they will, at a certain point, come in and control things in a way that none of us like if we get to capacity or if we,
And that's,
depending on, I guess, who decides that too. which
John,
is
I should
odd.
also point out the city which was Eugene, had accepted the fact that they were going to let all levels of service go to F. Which,
And
They have.
Just go ahead.
I have a question. So, one of the things with this whole talk of traffic, the applicant comes in and says, oh, well, we've done our traffic study and it shows that this is fine. The number of vehicles that we're putting on the road is just fine. And then we talk about, well, there's this development down here, there's that development down there. But one thing I don't see is, okay, what is the true capacity of that street? I don't get a report that says, okay, over the last 15 years, like this street can take this many cars. And over the last 15 years, we've put this many things on this street. So technically, by the rule, this is it's not, like, here's the pie chart of this street's capacity, and every time something gets built, some of that pie chart gets eaten up, so that we can physically look at it and say, well, now, you say that it's all right, but according to this study, and all of these things that have been already put on the street, really, the capacity of the street is only this little sliver of the pie. So I really don't see where you're going on this one.
I wonder though too, because traffic's so weird, Don's smarter about this stuff than I am for sure. I always wonder, people go for the path of least resistance. So that street might truly have their pie full, and people will realize that, and they'll just jam over to another street and fill that pie in too. And so sometimes when you're looking at this, you really are going to slowly affect everybody.
Most of the
not
traffic
just the
studies-
main arterials.
Well,
The traffic studies do that, though.
Yeah, yeah.
They'll actually show that bleed out. I guess one of the things that I mentioned, and I'll mention it again, and it might help Commissioner Patton, and that is, one of the things I don't recall seeing, it might be there, is when we talk about, this street is currently at level of service this, and it's going to go to level of service that with all of these changes. And that would give you some flavor of where it's at. And levels of service have specific criteria related to how long you wait at an intersection to get through it.
Yeah, and see,
Yes.
I guess what I'm getting at is we want, as commissioners, sometimes we want to say, look, we have a real concern about this, about the street, about the trip traffic on this. And a lot of times we feel like, well, they're saying that the study's fine, but I don't have something up here to be able to say, no, this is not right. These numbers don't jive. So I have to say, well, okay,
Yep.
your
Yeah.
study works.
Yeah.
So, is it possible? I know this, it just is kind of boggling my mind because I know about the pavement, survey and all that stuff. Is there a way to really get a comprehensive thing so that if a development is coming in the packet or whatever, we can say, this is actually this capacity of these streets, and this is what sort of impact of the amount of capacity that these streets will actually have. So we have numbers in front of us to say, look, we're going to deny this because we don't trust your traffic study, and this is the reason why. Is that possible?
Yes, there's a number of things that you guys have thrown out there. I think there's not a great understanding, and part of that is I think we need to provide more information through our traffic consulting. We're using DKS as our traffic consultant, and I think that's...
To make it part of the staff's packet of evidence
So
for you to consider, is that what you're saying?
Yeah.
And I think there's several things here. One is the level of service, which I think a much better understanding of what that is. And Canby is getting more traffic, and you have several things going on there. You have average daily trips, which is a volume that you have, and then you have peak hour trips, which are your rush in the morning and in the evening. And then ODOT is involved with volume to capacity. That's how they're measuring each intersection along 99 East E. That is all being factored into and looked at, and there's several things here, and one of those is leading into comments about additional things in the items that would be up and coming, which we're hoping to do a work session with DKS, with you as the planning commissioners and council soon. That's my objective. That would help, I think, in that. In the near term, I think having more information and a more robust assessment of that, what you're talking about, and some of this gets complicated because there's exceedance issues as well in some circumstances, but then you have to mitigate for those. You have to pay beyond the SDC to mitigate for those impacts, and so that's how DKS is looking at that as well. Back to your point, I think level of service, in terms of what that really means, it is more congested. If we're looking at the adopted level of service in the current plan, it will mean more congestion. That's just the way it's really adopted in the plan.
Is that the 2000?
2010, it's the 2010 TSP, and so that's really kind of the basis here. But I do think that an understanding, so you're not, questioning that is important, that we provide more detail, more analysis. And part of that is, because staff doesn't really have a transportation consultant. We don't have a transportation staffer. We're using a consultant in that place. I've come to somewhat of a conclusion that it feels like we need to probably have those folks from DKS at probably every hearing. We've not had them at every hearing, and so staff is taking on that analysis piece, which becomes challenging because our staff is not really, we're not transportation experts. We understand it enough to explain the general details of it, but we're not trained as engineers. And so that, I think, is part of that, is having more of an explanation through that process, more in our staff report, and more of an explanation, so you feel there's a more of a comfort level. Traffic is very much an emotional thing because you experience it, you feel it, you see it, and you realize it when you're in it. I think what we're trying to do is make sure it meets the standard. Meeting the standard may mean that traffic increases in its congestion. That's the balance here in the whole dynamic here. So I think everything you're saying is something we're talking about as staff, and I've been talking internally about having a work session to get more understanding so people really get that. We definitely need to update the TSP, the 2010. I think we're still operating where we are calibrating this so that we know what the level of service is, but a refresh of that, which will happen. We're planning to hire a consultant in 2022. About this time next year, hopefully we'll have that already approved in the budget for going ahead with that work. Yeah, go ahead.
So, sorry to interrupt, I guess, but it comes to mind, because it sounds like Commissioner Patton is asking whether or not, basically, you could have a de facto in the evidence amount of traffic study baked in. I know when you work with traffic consultants, they look at RTSP, and then they look at kind of stuff that you guys have provided for them, as well as doing their own research and coming up with this.
They do, and I just don't, I think it's not necessarily quantitative enough for the commissioners to really fully grasp. This is my belief anyway. I'm not sure if I'm correct here, but if there was more information that was provided, that it would give you that greater level of assurance versus a summation. Is that correct?
For me, it would be helpful to know what the current acceptable level of service is for the city.
Okay.
And if it's street by street, then that needs to be somewhere where I can see it. And then it would also be good to know, how is this, where is it headed? This is the acceptable level, where is it? And so we know that's a starting point, and that would help, I think, Commissioner Boatwright know about where he's at more, and perhaps get some reassurance when a traffic study comes through and say, yeah, we're adding these 800 trips and we're at level C and we're going to stay at level C. He may still not believe that,
Well,
but at least he'll know where we are
and
and what they're saying it's going to go to. It's going to stay within this acceptable level. And, I'm just saying that that's something that is, my previous jurisdiction was always treated very lightly because it was so poor. I mean, planning and transportation did not want to talk about that from a land use standpoint because, we're land use, we're not transportation, but it's all interlinked.
Yeah.
And, so when you find out as a land use person that they're letting the level of service go to F in all the city streets, which is that's like a 10-minute wait at a major intersection.
I think part of
That's
this.
not good.
I think part of this. Okay, I'm sorry.
Well, there's a really, Commissioner Patton will can attest to this. He lives on 22nd, and there are speed humps there, speed bumps, up and down 22nd. Before those speed bumps were there, people were coming up 99, getting off on Territorial, so that they could miss all the traffic going further on down 99. Coming off, getting on Territorial, and then coming up Birch, going down Knights Ridge Road, and then going from there. Well, once those speed bumps were put in, that traffic, and people were speeding up and down 22nd. There's a lot of traffic. And once those speed bumps were put in, there was a noticeable, and I don't mean just, there was a big difference. In
On
the,
on another street?
yeah, it all went back down to, was it Holly? People would go down
Yeah,
to
Holly.
Territorial.
Or Ivy, maybe?
Ivy,
Yeah.
yeah, Ivy. And they would, and instead of going all the way down to 22nd, they'd get off onto Ivy because there weren't speed bumps, there, you know, it was, people, like you said, they take the path of least resistance.
Yeah.
And they're gonna find their way around it, whether it's going down 22nd, Territorial,
Yeah.
Ivy, whatever it is, to avoid 99. And Commissioner Boatwright hit the nail on the head. What DKS may not be looking at is 5 years down the road, when all that tolling happens, more traffic on 99, where's all that traffic gonna go?
Yeah.
We don't have the capacity for, in my opinion.
And
But I'm sure we're gonna hear from DKS, oh, it's fine, you know?
Well, part of that, if, oh,
you go
either way. Okay, sorry. So I think sometimes part of this is, you know, how much do we want to make as part of each individual record, right? Because you really could have your TSP as part of every record, or especially if you have a new one that you like, and it has certain theories in there or whatever. But I think part of it is you have to assume that whoever comes in and is the person, the expert, that they've looked at that and they've actually accounted for it. And then I think the further layer of trust is you have to trust that the expert, Don, has actually looked at them and made sure they looked at it and that they're not hokey numbers. And so you can always ask those questions too. It's like, you know, I want to hear from staff whether this jives with our TSP and what it means. Because that he is, in a sense, he's not maybe a traffic expert, but he is an expert. And so now you have another expert in the room that if you ask him the question, at least it's a battle of experts. So it's like type of evidence against type of
Well,
evidence.
when it comes to traffic, here's the issue. It's admittedly, Don is not a traffic expert, and
No,
there
he's
isn't anybody on his staff that is a traffic expert. We are not traffic
Yeah.
experts. And the applicants are often required to get impact studies.
Yeah.
But the folks out here, the neighborhoods that are affected, these are guys that they're not shopping down at Saks Fifth Avenue or Nordy's or anything like that. These are guys that go to work, they put in their 8 hours, they can't afford,
Yeah.
even if they combined all their resources to hire a traffic expert
Yeah.
or a company that is an expert in traffic. So we're all of us are at the mercy of DKS.
Yeah.
And do we trust DKS? That's the question. Now, I can trust Don to a fairly well, but again, he's relying on DKS
Yeah.
as they're the experts, and he knows he's more knowledgeable about it than maybe we are, so his level of trust may be higher than mine, for example. I'm just saying that,
DKS would have more credibility if they brought bad news once in a while.
yeah, if they said, no, you can't.
They never bring bad news.
No, it's always all.
So you do this project, you have to widen the road.
That's the problem.
Another 500 trips a day, it's all right, everything's all good.
I think the trust factor could be substantially increased by the greater information to you as the body. And I've worked with DKS in the private sector as well, and I mean, they are primarily a public sector, and this is for other cities, when I was working for other cities as a consultant. And, you know, they do tons of comparable cities. Most of the smaller cities, they're doing the same thing. So their reputation is really strong. They don't do very much at all of the private side of things. So they're not dealing with private developments. That's kind of their niche. I think, that being said, I think that the information that comes to you to help you quantify that, so that one suggestion, and if there are others, about what is the level of what is the acceptable level of service? What is it going to be with this development, and where is it heading? If there's other questions that you have that we can ask them to address, that would be, I think, most helpful for us. Then we will make sure that is in there. Having been here, 7 months roughly, I recognize that, like, a lot of jurisdictions have many more people at these hearings, and some of them are staffers. And so that's part of the challenge, is that we need more, I think we need more expertise, both in the analysis part, and I would really feel like, if we, largely the DKS is, they're being, the funds are going to they're coming from the private developers. They either have a choice of hiring them or another consultant, but they're essentially working for the city to do the analysis. But I think more information that would be giving a greater level of confidence. Traffic is a very complicated subject matter. I think that's part of it. And when you get into these large industrial, for example, projects, and there's a lot of detail in these about, and some of those get into like, well, there's an exceedance, and then there's a mitigation of, more than $500,000 on top of the system development charges that they would already be paying. Those are looked at very closely by staff in terms of what that whole issue is. Back to Joe's point, it's not just like, hey, we're just going to let it go. There's a lot of back and forth on these about what that should be. ODOT is involved in that as well, because it's their system, and so they have to buy off on that. Clackamas County is also involved. So those are the parties that are kind of at the table here. It's, can it be improved? Absolutely. I think there could be more information provided that would give a greater level of confidence. I think that's the challenge, and, traffic is probably the number one issue that people really have a problem with when there's land use. I mean, it just is, and that's universal across, every place I've worked. Some places have had moratoriums because it was so bad, and you reached a level of service that you couldn't put anything more on it. That's not my goal at all, or the city's goal here. Part of it is there's not a crystal ball as to what that system's going to look like. When tolling comes in, that's not something that's 100% predictable. We are working with ODOT now. I'm coordinating with them on trying to get them to look at the diversion factor through the city. What is that percentage that they're anticipating? Where does that hit on the intersections that go through town, and should there be mitigation as part of that project for tolling? And that's part of, because it is a challenge for us in the city, and ODOT is looking at that in their environmental impacts review process now. So there's an ongoing dialogue we're having with ODOT and their consultants about what intersections should be studied. That all needs to be addressed and assumed in the TSP that's updated. I totally agree, because I think that's a factor. That may be 3-4 years out before the tolling becomes a reality. It's a ways out, but that's something that is a serious issue for the city.
Well, so real quick on tolling, you coming from Rochester, I mean,
Okay.
I grew up in the land of tolling. Like most of the highways in New York were tolled. And, in the end, it's like, do I want to go around about this and go over here and sit through all these lights, or am I just going to suck it up and pay the $1.25 to take the throughway? I'm going to pay the $1.25 to take the throughway because I don't want to sit through the 10 lights down 99E. So, there will be some fluctuation in there, but I think in the grand scheme of things, like half the people going on 205 are not going to all of a sudden be on 99E.
But, I'm sorry, but there are interstate freeways all around Rochester, Buffalo that aren't tolled.
Correct.
And they're doing just the opposite. I mean, the throughway is basically goes, it is tolled.
Yeah.
You got to get on it, pay your toll, but it's not, most of the traffic around the city doesn't pay that toll until they get out and hit the throughway going through the state.
Yeah, but the way I see it, if it's me and I'm trying to get from point A to point B, the last thing I'm going to do is come down 99E and sit through 15 minutes of lights and traffic to avoid paying $1.25 to be on the 4 lane. I mean, I believe that there will be a hit once they do it, but I don't know how long that hit will be. But that's just my opinion. But back to the traffic thing, what I'm trying to get at is we as commissioners are an extension of the community. And so when we are up here grumbling about traffic, the citizens come in and say, well, the reason I don't want this is because of traffic. Whereas if we are armed with that information to be able to say, in a layman's terms, okay, we are at 50% of the capacity of the street, or 75% of the capacity of the street, or so on and so forth. It allows us to be an advocate for the folks in the audience, so 50 people don't have to come in and say, well, we're worried about the traffic. That's if we are apprehensive about the thing, they are apprehensive about the thing. The more that we can be prepared and not show that apprehensiveness and be informed of those little things that come up every time will help speed this process up and put the faith in those folks that we are actually doing what we're doing.
And all great points, and I mean, we started with this, it needs to be added on to, but we didn't always have the summary, when I came on, and they've got the summary now, and I think we can add to that. I mean, all those are critical things that, it's beyond an executive summary. You guys want the detail, and that can be provided.
Okay.
Yeah.
Well, and I think that's laudable to want better evidence so you make a better decision. So, I don't think the city can necessarily afford, a resident expert to be in here all the time, having that, spending that much money to have somebody here. But I think there might be some sort of middle ground where you do have more of the evidence there so you can kind of actually have something to question.
Yeah.
Does a city like Wilsonville, Oregon City, did they have an on-staff traffic expert, so to speak?
I can't speak for each city. I do know that there are a number of cities that DKS is managing. They're doing exactly the same thing and I don't know which of those cities they're doing, but they're involved with a lot of cities in Clackamas County. So they're just kind of putting it out there generically. Pretty much every city that's of the size that needs a consultant is using them.
Yeah. Well, and the other thing too, back when I was originally on council, we had a very robust planning department, and then the housing market crashed, and they stayed around for a while, and then it all had to get dissolved. So, I understand that we can't go back to doing that because who knows how long this lasts. And sitting on the budget committee, I know that even for what we're paying, and correct me if I'm wrong, even for what we're charging developers, it's still not enough to fund our planning department. So, I mean, I know that feasibly you cannot bring all these people in. We have to rely on these consultants, but we have to be sure that a certain amount of credibility is built up between the consultants and us so that we aren't sitting up on this dais and saying, I hear what you're saying, but I don't trust you. Because that's a problem. We have to trust them because they're the ones that are steering this city.
Yeah.
So that's why we've got to fix that relationship so that the folks out there don't question them through us.
Yeah, and I sensed that before you even brought that up.
Perfect.
And I mean, I knew that was like a problem. And so it's kind of how do we fix it? And we've had multiple conversations with DKS, and I think you're starting to see more of these situations where they are present at hearings, and we clearly need to give more information. I mean, I think it's a challenging job as a planning commissioner to begin with. There may be circumstances, even if we bury you with information, it's still uncomfortable.
Well, sure.
But I think we can do better.
Well, I think part of this too, part of the benefit of the workshop is Don gets to hear the nitty gritty of what you guys are actually concerned about. So it takes a little bit of that trust too. But Don better start asking the traffic questions more every time of each development too. You know what I mean? And then you kind of have to trust, like, did you ask those questions, Don, that we want you to ask? Kind of when you're working with the applicant, so that you know that you'll get hopefully a better product coming in front of you too. So
Yeah.
if that helps, but because we are a pretty lean organization, we have to trust that Don is carrying your torch and telling people, these guys care about traffic, you better have something good to say about. You know what I mean? You better actually cross your T's and dot your I's when it comes to traffic, because they're starting to take a hard look at that every time now.
Yeah.
And I think he will do that, so.
I think, going back to what Commissioner Patton was saying, if we knew, okay, here's the upper limit. There is a hard number up here. And where are we on that scale of 0 to up here? And I don't know about anybody else here. I have no clue what that upper limit is and how close we are to that limit. Now, that may be a moving target. I'm even less of a traffic expert than Don is, and it isn't even close. So, but I think that we have to know what that point is, so that we can at least have some idea of.
And just to, there's a model that DKS has as well, and I think they need to talk more about that for the city, and that's holistically. I think what we're dealing with on these project level activities, though, is a geographical distribution of trips, and there's a number of trips, there's a distribution of those trips, and so there's a limited geography of those trips. Holistically, though, there is a model that DKS has. I think part of that is that story's not really necessarily being told in its detail each time there's a hearing.
And I would suppose that part of that, the onus of part of that should be probably on staff to tell it, because you're only giving the applicant 10 or 20 minutes or whatever it is, right? So you can't unpack a 10-minute traffic story and then leave only 10 minutes left. So maybe that just has to be part of the evidence that staff puts into the record for you guys, or at least in part. And then if there's highlights that they can approach. Because from a fairness perspective too, I don't think we can't demand a half hour on traffic and only leave 10 minutes left for all the other stuff.
Sure.
Yeah. So and I'm just putting that out there as a man of reason.
Yeah.
So we are at the end, and the other thing, just remember, if you are going to return, or even if you're going to leave with the packet open at the end of the hearing, but not quite yet at the end of the meeting, that date certain just gets announced, so, because that will be the only announcement of that time, and then you don't have to go out and wait 20 days to officially announce it, because that will be sufficient enough to follow our code. So if there is going to be any sort of set over for any evidentiary reason or whatnot, just make sure that you make that record that you announce that date certain of return. And that's what you have to consider when you're doing these. I am happy to have come in here and done this. I think we all learn a lot from each other. So thank you for your time.
Thank you.
Oh, thank
Yeah.
you.
Thank you.
So I got one thing to mention, though.
Yeah.
Water.
Oh, yeah.
Our water tastes terrible.
I'm starting to hear that more and more too.
And I lived here 27 years, and the first 22 years, the water was great. Some of this has to be from the growth. I know the river's low. We always hear this climate change, warming and drought and all this stuff. My daughter lives in Malala, and they're rationing water, but their water still tastes good. And I know we've got a algae here, but
Weird
it's
algae.
something that we need to start thinking about too. I believe is because we've got a real problem with our water in the city.
And
Well-
I know they were, sorry, Commissioner Patton, what were you
Well,
saying?
and I think, and this we might be veering off here, so I don't want to, but from what I understand of it, one of the problems is that the amount of money that it would take to fix the problem it's a pretty big dollar amount. And in the city charter, the Canby Utility is limited to how long they can go out for a bond.
Yeah.
So they can essentially only get a bond for
the
5 years.
Yeah.
So trying to bond a $5 million water filtration system for 5 years, they can't do it. So in my opinion, it would have to come down to the
Yeah.
city charter being more realistic for Canby Utility to be able to fund projects like that so that they can get a 10, 15-year loan for some project like that.
And I've heard, I've participated in conversations and observed them where can be asked about that charter change and, or Canby Utility did, and where we have other items. Charters are hard because you have to get, 10% of the electorate to even signatures wise and then get it on the ballot. But sooner or later, we will have some charter, and then you wonder, how much do you make it a full package? Because there might be some, poison pills in there that people will reject, and then other things they like. You see what I mean? So it'll be a little game about how we go about that. But you're exactly correct in that. I think that's one of the issues. I think the other thing is they don't always understand different types of revenues that they might still be able to go, and so they need to kind of maybe explore a different type than just the bond that they're limited there. A general obligation bond, I think, is the 5-year limit. But the water itself, I'm with you in that I think the hope is that they figure it out. I remember Canby Utility was trying to also purchase water rights to not just the river itself, but to some of the aquifers and things underneath. And then they have the access to the Willamette, which, may or may not be great, but it can be. And so hopefully some of their strategies, I know they were asking about the rights of the water even under when Canby Area Transit was purchasing some of the property by Pioneer Pump. There's some water rights that I think were, attainable through that land transaction, and I believe they sold or gave some of those water rights too. So I mean, there is other avenues I think they're trying to get creative with to have more water on tap and available that might not all have the algae problem. So.
Well, I just thought I'd bring that up because that's something I think we need to think about if we don't address it pretty soon with all the building and stuff. And actually, I think there's going to be another, with the interest rates and what's going on at the federal level, I think we're probably going to see a slowdown here pretty soon.
Yeah.
Just guessing,
Yeah.
but that's what I think.
Well, I've seen the real estate market's taking a weird little turn right now, and they're calling it more of a buyer's market because it kind of got a little weird. So, but I don't know. I mean, I'm no expert in any of these things.
At
Now I'm just
At
talking.
$100,000 a home, it's still not a buyer's market.
Yeah.
I'm sorry. I mean, it's gonna have to
That's low-income housing.
right? I mean, no, we are not an affordable city
No.
by a long shot.
No, and that's all unfortunate too, but then some of the ways in which we've been forced to try to address that aren't necessarily, the restrictions that you'd want to put on yourself either. So
Yeah.
it's hard. I think these are hard things. And what's cool is it's such a cool town. It's a really nice town, and I thank you guys for safeguarding it.
Yeah. Trying. Well, thank you very much.
Yeah, thank you so much.
Thank you.
I've got to excuse myself. If you notice how much
Oh,
of this
no,
I brought in.
we have some more questions for you. Sit down. Let me help you out there.
Okay.
So do we have to adjourn
Do we have to
officially, or are we
adjourn?
done?
I think that we've covered it, and yes, we should adjourn officially.
I'll entertain a motion to adjourn.
Some motion.
All in favor,
Seconded.
say aye.
Aye.
Nice, thanks, guys.
Thank you.
You.